Okay, good afternoon, everyone. I'm Karen Nichols. I am one of the facilitators for the course this summer. I'm doing the Certificate for Educators course, and I'm excited to have you guys here today for our open licensing webinar with Kat Walsh. I'm going to talk a little bit about her, but I did want to remind everyone that the session is being recorded. And we like to be able to see you and hear you on screen, but if you don't want to, we will post this video to our YouTube channel. So if you don't want to be seen in the video, be sure to keep your camera off. If you don't have a microphone, I think I might say microwave, goodness, I haven't had lunch. If you don't have a microphone, feel free to put questions and comments into the chat, and we will keep up with those with Kat. So I have two other facilitators here with me today. Would you guys like to introduce yourself real quickly?
Sure. I am Shannon Gunther, and I'm the facilitator for the course for open culture.
Hi, I'm Evelyn. I'm currently facilitating one cohort for educators.
All right, thank you. And if all of you will just go into the chat and tell us your name and your institution, that would be great, so we know who is in the room. We'd appreciate that. And while you guys are working on that, I'm going to go ahead and introduce Kat. Kat Walsh is the Copyright and Licensing Counsel at Creative Commons. She was on the CC legal team 2012 to 2015 during the drafting and initial publication process of version 4.0 of the license suite, and returned as Deputy General Counsel in 2021. She has nearly 20-year history in the free and open culture movements, including many years on the board of Wikimedia Foundation and the Free Software Foundation, and has previously worked in library policy, technology startups, and online community management. Kat is an advocate for free access to knowledge and for CC licensing as part of the infrastructure for an internet that belongs to everyone. As General Counsel, she oversees the legal support for all aspects of CC's activities, provides strategic input, leads the stewardship of CC's legal tools, and advises the organization on new programmatic initiatives. When not practicing law, Kat is also a bassoonist, violist, choral singer, and power lifter. She's based in, and I hope I say this right, Kat, Novato, California. So let me turn it over to Kat, and we'll get started.
Great, thank you. Yeah, it is lovely to be here, and I'm looking forward to answering your questions. I'll start with the obligatory disclaimer. I am a lawyer. I'm a lawyer for Creative Commons. I am not your lawyer, so I will not be able to give you specific legal advice. What I am going to do is talk as much as I can about the situations that you might find yourself in and the principles that you might consider, and like some of the details of the licenses. But if you want to ask me about a specific situation, I can talk about the principles around that, but I can't advise you on what specifically you should do. I'll probably tell you that you should ask your institutional counsel or somebody around you, but I can give you some information that you can take to them. I'm also, I see there's a couple questions in the questions document, and I know that sometimes people ask questions who aren't here. So I'd like to prioritize questions from people who are actually in the room. So I'll start by seeing if any of those questions are yours. Please raise your hand or point them out, and I'll get to yours first. Similarly, if you have questions that you didn't put in the document but you'd like to ask, I want to prioritize the people who are actually here. But if nobody's enthusiastic, I'll start picking ones out from the document. So if anybody wants to jump in, I like to keep this pretty informal and conversational, and otherwise I will pick out my favorite from the document. I will start with the one that I think is fairly straightforward to answer, which is number 3. Because CC licenses are irrevocable, is it possible for a creator to use CC BY and CND, take down or stop distributing what they've published, and later republish with a less restrictive license? So it is true that you can't revoke a CC license. Once you've offered under those terms, you always have to keep offering under those terms. But if you want to go from more restrictive to less restrictive, that's a pretty easy situation. Say you chose CC BY and CND, and then you changed your mind, you want to go to CC BY. That's great. If so, you don't have to continue advertising by NCND, like any copies that you put out in the future, you can just put CC BY on. It is true that if somebody finds a copy, like they can use it under the terms of by NCND, but there's no reason anybody would do that when they could use CC BY instead. So you can't revoke them, but like if you want to open it up further, that's great. Nobody will be confused by the more restrictive terms. Like nobody will believe that they have rights that they don't have. The opposite way is more difficult. Like if you released under a very open license and you decide you didn't like that and you wanted to close it up more in the future, say you originally chose CC BY and then you changed your mind and wanted to go by NCND, it would be the case that you wouldn't be able to stop anybody from using it under the terms of CC BY. So we do encourage people to really consider like what it is that you need from your published work before you choose a CC license, because it is true that you can't revoke them. But when you're going from more restrictive to less restrictive, that's usually not a problem, because anybody who finds themselves complying with the additional terms won't have a problem. But if they do figure out that you did release it under new terms in the future, they will only have more permissions, not less. I'll pick out another one that seems fairly straightforward. The legal status of CC0 in Europe and other countries where moral rights are inalienable and unwaivable. Is CC0 comparable to a license in these contexts? So yes, that's part of the reason why CC0 is the reason is published the way it is, rather than just simply being a public domain declaration. It does have a fallback license. There are some places where you can't waive copyright. There are some places where you can't waive moral rights, and where that happens, the license waives rights to the extent legally possible, but if you can't waive the rights, you can't waive them. It may be confusing for your reusers if you're in those jurisdictions. Often people who are using CC0 don't intend to enforce those anyway, but it is the fact if you can't legally waive them, you can't legally waive them. It's similar with the other CC licenses that aren't intended to be a public domain declaration. It does acknowledge that you waive your rights to the extent necessary to exercise the licensed rights, but if you can't do that, it's only to the extent possible under the law, which does make it confusing if you come from a jurisdiction where you really can't waive them at all. Hopefully, if you're applying these licenses, you don't intend to enforce those rights in a way that would make the license meaningless, but it does, like the difference in jurisdictions does make that a little difficult. In the United States, for example, almost all of these rights are waivable. Like if you say you release all your rights, you are releasing all your rights. You've put something into the public domain. But France, for example, where you can't waive your moral rights, you would have the right to enforce even if you put CC0 on it, and that's just a thing that most of the people who choose CC0 are not intending to enforce any of those rights, but it is true that the right still existed if they wanted it. And as always, if people have like questions or comments, or if something was unclear, please do say so in the chat, because I'll be happy to like clarify or answer additional things. So I'll move on to number 5, which somebody posted as more of a philosophical question. Some funders are now requiring researchers to publish under a CC BY license. Does a mandatory CC BY license take away control from authors over the use of their work? And they link to a Scholarly Kitchen article, which I looked at and largely talked about the ability of authors to like control the use of their work, particularly around misrepresentation, things like that. So this is always like a choice that you make as a copyright holder and a creator of work, like where you publish and what somebody does with your work. Whenever you're going to publish in a publication that does have policies, you're agreeing to follow their policies, like whatever they are. Or if you're taking a grant from an institution with grant requirements, such as an open licensing requirement, you are choosing to agree with whatever stipulations that they put on it. I don't think that the CC BY license is a particularly onerous one, but I'm kind of I am biased because I do think that it's a good way for researchers to share their work. particularly, and I am biased toward the United States. I am a United States lawyer, and this is the jurisdiction that I know best. In the United States, copyright is mainly an economic right. It's mainly meant to preserve the ability for you to make a revenue stream from your work if that's what you need in order to be able to publish. If you're being supported by a funder who is going to give you that money to release it openly, that's generally like in the US, it's like, well, you didn't need copyright to get that revenue stream. You got the revenue stream, and maybe you're not even seeing any additional money from it because you're supported by your institution. Like that money doesn't go directly to you. Things like that. You can have whatever you can have your own philosophical feelings about that, and if that's true, you may be pickier about which grants you choose to take or which publications you choose to publish in. One of the points made in that article was about misrepresentation in particular, and in that case, I think that some of what they had to say is a little bit misguided or a little bit fear-mongering, in part because I think probably all of us know that you don't need copyright permission in order to misrepresent somebody's work. We've all seen plenty of misrepresentation of work that is all rights reserved because it doesn't depend on copyright. You're allowed to quote under limitations and exceptions, such as fair use in the United States. Or if you're simply going to paraphrase or refer to ideas, copyright doesn't control that, and you can misrepresent somebody quite well without needing to take exact copies of their work. The CC BY license does control publication. So if you are concerned about commercial republication of your work, that is a thing that you might consider. And if that's something that would trouble you or that you don't agree with, you may reconsider whether you enter into an agreement such as that. It often is not the case that most of the uses that happen, especially of scholarly works, are things that you'd probably be happy to see. They get republished in, for example, Wikipedia. They get republished in educational textbooks, things like that. There aren't in practice a whole lot of uses that people would object to. But if that's a thing that does concern you, that is a choice you have to make whether you would like to take those agreements or not. So let's see. I think we've had a few more people join since we started, and I'm going to say that I'm going through the questions document right now, but I do want to prioritize the people who are in the room. So if you have a question that you want to ask, please either unmute and ask it or put it in the chat, and I'll get to that first. Otherwise, I'm going to keep going down the document. Let's see. So here's question number one, which is I'm not 100% sure that I understand what the asker is asking, so I hope that I will get this right, which is, I have a researcher who is lead author on a published article, which he has published CC BY NCND, and now he wants to use the entire article in his thesis. He says it's a traditional thesis, and the chapter is essentially a published article, but I had to tweak it to make it fit with the chapter format. He wants to know if he can do this, and he needs to show permission to include the article in the thesis. So this, I feel, depends on the agreement that he's made with the journal. Like, did he assign copyright to them, or does he still hold the copyright? Because if the author still holds the copyright and doesn't have an exclusive agreement to publish with the journal, then he can offer it under any additional licenses, make any other additional terms that you want. The CC licenses are not exclusive, so if you offer it under one license, you can offer it under another license. What you can't do is revoke your CC license, but you can offer it under any other additional terms and conditions that you like in different publications. So for example, if you've published something under CC BY NC to the world, you can offer a commercial license to somebody else. If you publish it under CC BY ND, you as the rights holder, like it's your material, you can make additions and make remixes. You just haven't authorized the general public to do that. But if he did assign the copyright to the journal and it is copyright that journal under by NCND, that would be a different case. In that case, you'd have to look very particularly at your agreement with that journal. In fact, you may not be able to republish it at all, and you'd have to really look at your agreement. If you are reusing it under the CC license, you would have to follow the terms and conditions. And you would not be able to make a derivative without getting specific permission or otherwise, otherwise negotiating with the copyright holder, who would not be you anymore. It would be a journal or an institution or a publisher. CC licensing is sufficient permission to republish it. You don't need a separate permission statement if you want to republish something that's under a CC license, so long as you're able to follow the terms and conditions. But if you're not the rights holder anymore, you may want to make sure that your publishing agreement that you've entered into does allow you to do that. Whether it's a small enough change to get away with in the case that where you did have to follow the terms and conditions, the answer to that is maybe. The ND license doesn't forbid all changes. You can make some format changes, you can make copy editing changes, anything that's like not really creative and wouldn't be considered a derivative under copyright law. A derivative is generally when you've taken a creative work and you've added enough additional material or creative input to it that it is the original work combined with new creative work that would by itself qualify for copyright. If you haven't done that, if you've simply made some small tweaks, then you probably have not made a derivative. If you have like made substantial revisions and additions, it probably would be a derivative, and that's a question that's very fact specific. So that's a thing you might have to consider with your own institutional counsel. And I see one more. Oh, good. I see there's somebody in the doc, so I'll take the number 4 that's already in there. General thoughts about AI, recent rulings in some of the AI and fair use cases in the US, etc. Then, general thoughts are that it's complicated and that anything I say right now might change in the next few months, the next year, things like that, because it's such a hot topic and there's such a lot of both interest and like potential legislation and litigation around it that anything could change by next year. So keep watching the space and watching the news to see what happens. AI is interesting because particularly we've thought of a lot of the things that are happening as falling under limitations and exceptions to copyright. And I think some of the recent cases in the US in particularly have underscored that using material to train AI is not a licensed use, it's a fair use. A lot of people approached CC, particularly when the generative AI hit the mainstream, and wanted to know if number one, if training AI had to follow the CC license terms and conditions, number 2, if we could change our licenses to address AI specifically. The CC licenses extend only as far as copyright does, but whatever exceptions and limitations, such as fair use, exist are things, the licenses don't override those. We believe that the limitations and exceptions to copyright are important. We don't intend to extend copyright. We only intend to provide alternative terms and conditions for people who want more open terms for sharing their work. So we have not updated our licenses to address AI specifically, particularly because it was our thought that this was likely to fall under limitations and exceptions. I think a lot of the recent cases have upheld that training does fall under limitations and exceptions. Particularly, it's not making exact copies of material. There are a few isolated cases where that does happen, but in the general case where you're simply taking that material as training material and you're, making abstractions of it, you're using it to change model weights, and then like what comes out of the AI isn't an exact copy. It's something that was like informed by the material, but not an exact copy of it. That's generally not a copyright infringement. I don't know if there will be any legislation, et cetera, to address this. I know there have been, particularly there was a Senate hearing recently where there were people in the content industry in particular who were upset about those rulings and like who want to see more legislation, but I don't know if that will actually happen. There has been more movement in the EU. In particularly, the EU has a right to opt out of AI training. So a lot of it does fall under exceptions. There's a text and data mining exception, but if you have specifically marked your material that you would like it to be an opt-out, that is something that has to be respected in the EU, but not in the US. Take a drink here. Some jurisdictions, such as Japan, have specific legislation that like allows AI training. Other jurisdictions are still considering. but it's still a hot area, and in particularly a lot of it feels upsetting to people who have put their work out in the open. A lot of people choose CC licenses and other open licensing because like they want it to be reused, but they want their works to be part of a community, or they want it to be they simply want credit for their work and seeing their work used for AI training. It feels upsetting because they're not getting those few things that they ask, they're not seeing, even though the work is being used and distributed. To that end, one of the initiatives that CC has been putting forward over the past year or so has been a thing that we're calling CC Signals. If you look at our social media and some of our other materials on our website, you can see more about that project and how it's developing. And what that will be is a set of markers that are not licenses, they're not legally binding contracts, but are a set of signals that will indicate how a creator would like the work to be used in the context of AI, and some of those would include, giving credit, the nature of the use, like compensation, things like that. And it's still in development, but you can look a little bit more on the website and see like where that's going. We're hoping to get more industry collaboration and have it be adopted as a standard. And you can see that Shayna in the chat has put some more information about AI, CC and AI in the Commons in there if that's your interest. All right, and I see one in the chat from, it looks like Kiara. If a GLAM gives you a work to share under a CC license on Wikimedia Commons or similar, saying that it owns full copyright of that work, can you take their word for true? What obligations do you have? What responsibilities if you didn't double check and it turns out not to be true that they owned full copyright? So I would say, in general, you should be able to rely on a statement that somebody like that like some institution has given you about the right status of the work. But I would say to use use the smell test. Like if you know, or if you have reason to believe that they don't know what they're talking about, that they're not the rights holder of that work, like I might ask them for additional additional proof for like, how did they get the rights? A lot of institutions are not actually the rights holders of the works that they are stewarding, especially like works of contemporary artists, things like that. They may even not, you and they may not even be talking about the same thing. They may believe that they have rights, for example, in the digitization of the work, but not the underlying work. So if you're suspicious of a statement like that, I would probably go and ask a little bit more about it before like making a statement to the general public. It is possible that you could be liable, for example, like secondary copyright infringement if you simply went on a statement that was unreasonable. If it is a thing where you really wouldn't have any reason to believe that they weren't telling the truth, maybe they were, it is something where it's plausible that they could have rights in the work. The rights could have been assigned to them, or it could have been a work for hire, or things like that. You should be able to rely on it. It should be, and if the material is an error, it shouldn't come back on you. But if it's something that seemed unreasonable on its face, I would probably double check that before. I think it's not very frequently that like that these things ever come to court, particularly if you're simply like an individual who is trusting the word of an institution. Like if it comes to court, it's probably not going to be your responsibility, but it is a potential thing, and it certainly would be a giant headache if somebody like we had to sort out who is responsible for what. So I would say to double check things if you believe that maybe what you've been told is not actually the truth.
Hey, Kat. I have kind of a follow-up question here. Because this is a really good question, and I was a librarian for a long time, and I would get asked this a lot by other librarians and archivists and stuff. And apologies if you addressed this because I was zoning out for a second, but I know a lot of GLAM organizations will, when people donate things, for example, to be digitized and uploaded to a collection, they'll have paperwork involved, and they'll be like, please sign this thing, so that, you know, and you signing this thing is your promise that you do own all the copyrights and all the other rights to let us do this thing. Like, is that a useful thing for libraries and institutions to have on file? Is it sort of a thing we do just to make ourselves feel better, but like legally it's kind of meh? I'm just curious if you have any kind of general advice there.
Yeah, I think it's always better, like, if you can if you can document like what you think you're agreeing to, like even if it's not like I think it's always good to be able to point to like, oh, here's this agreement that like here's what we thought we were agreeing to, like back when this happened. Like it's a pain to keep up with all that paperwork, so a lot of organizations don't do it. But if you can point to it in the whatever you have to point to in the occasion that it does come to a dispute, like I think it would be helpful.
Awesome, thank you.
Yeah, and it may be the case that, for example, the person who thought that they had rights to sign away didn't actually have those rights, and maybe that still becomes a mess. But like, at least you can point to like, oh, here's what we were relying on, here's what we thought we had to rely on. So. Let's see. I see there's a new one in the document, which is, do accessibility interests take precedence over copyright interests? I learned about items for the visually impaired under the Marrakesh Treaty. Does that include voice recordings of books? A related question is, what are videos that need to be captioned for the hearing impaired and deaf? Can those be captioned without involvement from the copyright holder? So in most of those cases, exceptions for that will be written specifically into copyright law, and there are specific accessibility provisions written into US copyright laws, limitations and exceptions to copyright. I forget offhand what exactly those are. I know there are some provisions, for example, making accessible to like blind and print disabled. You can make braille copies and distribute those. I forget the specific terms, but there are several provisions that make it possible to make accessible copies without that are explicit exceptions to copyright that the copyright holder can't prevent. Some cases are not specifically noted, and you would have to make a fair use analysis for those. Some of them are fair use, some of them might not be considered fair use. If they're not specifically written into the law, it's much less specific. And even things like the Marrakesh Treaty, every signatory of that had to put a specific implementation into that into their law, and some of them look a little different, and some of them have been imperfectly implemented. So every country will probably have slightly different provisions on like what accessibility measures are considered to be exceptions to copyright. But in general, those will be written as specific exceptions to copyright, and anything else will have to be we'll have to see if it falls under a fair use exemption. Oh, great, and I see that came from somebody, Gregory, in the room. Oh, and it looks like you'll have a webinar at the end of the month, which is specifically about making OER more accessible. Yeah, and I will say that my personal opinion is that, number one, a lot of those should fall under fair use, but it's always like it's always hard to make a yes and no on fair use, which is something that's very fact specific, and often you can't get a final determination on without the courts. Number two, if you're really doing it in a way that that the original market isn't serving, and you're not really affecting the market for the original work, like I feel like it would be a bad look for anybody to to litigate against you for making accessible copies to people who couldn't otherwise receive those works. But it is the case that like only what is specifically written into the law and what falls under a fair use analysis is explicitly permitted.
Thank you for that. If I can follow up a little bit. So I teach, and I have taught in person and I've taught online, and I understand that when I teach in person, I can show a copyrighted video to my students in the classroom, and that's never been a problem. I teach online, and do I need to show, right? And do I need permission? I understand that the copyright's different for that. And I have learned about the Teach Act in America, right, from 2002, 2003. And but then it's also true that everything has to be captioned, right? For all of our, and we don't have to wait for, we don't have to get a request from a student who's deaf or hard of hearing. We have to have a caption first, right? Because it has to be there. And so then this question comes up, and the faculty that I work with, they'll often ask me this question. So thank you for that.
Great. And I feel like my feeling of this, which is not, I'm not legal advice here, on a case where like you have legal access to distribute this copyrighted material to your class, but you need captions on that material that weren't provided. Like that to me feels like simply like a format shift rather than like you're creating a new work or you're making a copy. But I don't know offhand what if there's any legislative or any case law precedent on doing that. Like it feels like if you're not, if you're required to do that for accessibility for your classes, that it feels like it would be very silly for the copyright holder to try to stop that, but very silly has not always stopped copyright holders.
Thank you.
Yeah. Shayna says, the vibes-based answer. My hot take, fair use is all about vibes. I think this is in fact true. And like if you look at litigation, often a judge will try and will make a distinction that is based on the law, but goes more like this feels fair, this feels unfair, and then we'll go back to the factors to try and justify that decision, which is a very unsatisfying answer if you're trying to get a definitive yes, I can do this, no, I can't do that. But often like my advice to, have I complied with the license or not is like, what would you feel comfortable explaining to either the rights holder or a judge? I think fair use is also something similar to that. Let's see, do we have any other questions from the room? Otherwise, happy to talk about any topics that have come up before, or like any other random questions. I see one in the chat now. I've come across publications with the CC BY license, but with an added note such as except for the images. If I want to share such a work in a learning management system, what should I be aware of, particularly regarding the use of images? I think for those, you will probably have to look up the licensing for reproducing the images, because you will have to reproduce the licensing information for all of the works that are included. The CC BY license is straightforward for the text, but the images, like some of them you may not be able to redistribute. Hopefully they are available to redistribute, but you might have to, for example, acknowledge a particular a different licensing condition, such as, used by permission, or maybe for educational purposes only. You'll have to look back and see what that is. If you're in the case where you're publishing such an article, like you're able to publish your text CC BY, but you wanted to use images or figures where you had to get specific permission, you want to make that as clear as possible for your reusers so that you can so that they know how they can reuse it, and if they can reuse it in their particular context. And for example, you may have to republish the article without some images. You may have to make substitutions. For example, if some are only able to be used non-commercially, or some are only able to be used educationally, and that's not your context, you may have to change or substitute that. Yeah. In general, like if you're the author or rights holder and you're publishing something, like the default, as much information as you can give to a reuser to let them know how they can reuse a work and who needs to get credit and what the licensing terms are, like that's always helpful. Like even if you're not legally required to give the information, it's all like, say you're using a public domain work, it's always helpful to the reuser because they don't know what you know, and they want to know if they can reuse and remix your work. Yeah. Yeah, any other burning questions that are coming up?
I have a question, but I don't want to take space.
I think nobody else is taking the space and you're good.
Yeah, go for it.
Okay. It has to do with, it's from the questions I see in the document from the prior session, and I'll give you my specific example. I wrote an article once about, I did a research study about when the Dodgers moved to Los Angeles in the 50s. And as part of my study, I reprinted, so this was all, I didn't publish this at all, right? This is just an assignment, but I was encouraged to publish this in a journal. So it'd be a scholarly article, right, in a history journal. And my essay, my paper included images that I had, they were cartoons basically, right, from the newspapers that were expressing opinions. And it's because I never published it, I never got around to asking about the copyrightability, because certainly those images were held in copyright, right, by the whether it was the artist or the newspaper or whoever owned the copyright. And my understanding of fair use is that, yeah, this is for critique because it's for a, I'm doing it to, I talked about the image in my paper, right? Look at this image, this shows, and I'm interpreting it, doing my job as a historian. But I also know that there's no way that I could only do a portion, right? I was reproducing the entire work within my thing. So is there an easy, probably not, it depends, but is there, can you share?
Yeah, it isn't, it depends. Like there is not an easy answer to that. I know a lot of people have heard like kind of folk guidance such as, oh, for fair use, you can only use 20% or like so things like that. And that's but for some kinds of fair use, like that's not possible. Like you need to, in order to critique a thing, like you need to use the guidance and the legal precedent is often like use no more of the work than you need in order to make your point or your critique. And if that's a thing where you've just got like a small image or a small cartoon and you need to use the whole thing, like that's entirely possible that that's a fair use. And I can't tell you in your specific case if that is or not, but it is certainly the case that if you needed to use the whole work in order to make your commentary, like that can be a fair use. It's not just like, oh, you use more than 20%. It's definitely not you.
Okay.
So, but
Thank you.
it is so very fact specific, but in those cases, like it may be. It's also possible because for works that were published before before the most recent revisions to the Copyright Act in or one of the recent revisions to the Copyright Act in 1976. If the copyright was not renewed, it could even be in public domain. Tracing that out is often like extremely difficult and ridiculous. There's not a very easy way to do it. And if you ask the rights holder, you may not even be able to find them anymore, or they may just say it's in copyright whether it is or not. So if you can't find definitive evidence, you should probably act as if it's copyrighted. But there's a good case to make for a fair use of a work like that.
Thank you.
Well, yeah, this is another thing that comes up for historical works. Any work published after the 1976 Copyright Act is like automatically in copyright for either life of the author plus 70 years or 90 years from publication for like a corporate work. Pre-1976, there were more rules about like renewal and about including copyright notices. I know the American Library Association and some other organizations have like guides to like, is your work in copyright? And as a practicing copyright lawyer for 20 years, I do not remember all these rules offhand, and I have to look it up every time I want to know about a historical work. So if you also have to do that, that is completely normal because they were kind of very difficult to follow. But it is the case for older works, like something that would be in copyright if it were published today may not be in copyright if you find a historical work. Which only makes things more difficult because there isn't a good registry system for that. Things that you may be able to look it up from the Copyright Office, but you may have a lot of difficulty in finding a rights holder or whether they actually renewed their rights and things like that. I like Shayna's the answer to every copyright question is it depends. Like I think there are some there are some things where you can give a definitive answer, but it depends a lot more often than like I think anybody would like, who, especially people where you're in a situation where you have to like justify to somebody like an institution or a funder like to make your decision. A lot of copyright, a lot of whether you can republish is a very much a risk assessment decision. So a lot of times the answer will be it depends, and the should you go ahead, you might want to make the analysis of like what are the stakes for your decision? Like, are you publishing a blog post, and if somebody you're not making any money from it, and if somebody complained, you would just take it down, and probably that would be the end of that. Are you publishing a textbook that's going to have a print run of 1 million, and like making a mistake on that would be very costly, and like all the situations in between. So it's very much like what are the stakes for this decision? Like, what kind of money is involved? Who's the rights holder? Like who's going to be liable? So sometimes like you just can't know the answer and your decision is to go ahead, and sometimes you just can't know the answer and you need to be conservative and use only things that you're very sure about. And what situation you're in is so dependent on like what it is that you're trying to do.
We still have about 15 minutes. Does anybody else have any questions?
I wish my college's general counsel would make themselves available in a session like this one. Yeah, I'm very happy that number one, that CC lets me do this and like has the resources to do this. Like yeah, I think we're generally like pretty. It's pretty difficult to like answer people's like legal questions, and I do say like I don't know a lot, or you're gonna have to answer your ask your institutional counsel. But it is like it is a resource we like to provide for the public, and along with our lovely certificate facilitators who are also answering people's questions all the time. So it's it's really cool for me also to hear what people are like actually struggling with like in their real lives, like what problems you're generally genuinely facing, and it's changed like over the past several years too, as more people are concerned about AI or like different publishing models come up. So I enjoy doing these Q&As and talking to people.
I love these sessions, and I think Creative Commons in particular has a knack for finding really nice and friendly and personable lawyers. I've got a family full of lawyers, and they don't always answer my questions as politely as Kat does, or as clearly. So I do appreciate folks who can, take a really kind of tricky or kind of obscure topic of expertise and kind of translate it into ways that that regular everyday folks like me can start to understand.
I have one, Kat, I have just a question that's you've already answered it before, but number 15 on here, I do get from at least one participant every time I facilitate. So I don't know if that's when you want to, since we have time, but.
Yeah, that's a good one. Fair use is such a difficult one because it's so dependent on like it's so dependent kind of on like what side of the bed the judge woke up on that morning, and very much on like the vibes, like does this feel fair? I do think that as much documentation as you can provide like helps, especially if you write it at the time you're making the decision. So it's, pardon me. So if you have to go back and dispute it, you're not just like kind of making up an excuse after the fact. You're like, oh, this is why I decided to do this. This is like, what I thought my alternatives were. This is why I needed to use this work in like, and why I couldn't license the work, or why I couldn't like substitute some other work for it. I think it can be helpful. Like it may not be definitive, like the other factors will probably outweigh it. But I think there can be some cases where it could be harmful, like if it came out, for example, like that that there were alternatives you could have used, but you didn't want to, for example. So, you know, and I think maybe in that case, you might have a good discussion with whatever legal professional you had access to about like whether that would be helpful. Yeah, this is one I have to think about. I think it could go either way. I think it could be helpful or it could be harmful. I think where you have a very good case, it's more likely to be helpful, but where it's a little bit more dubious, it might it might not be in your favor. I don't know if that is helpful. I do think like actually I do think like having a document where you explain the reasons why you think you should be justified to use it can be helpful. It's just like that if you find yourself in a position where you need to where you've also written out the reasons why the case might go against you, that might and you had to produce that to somebody, that might not be something you wanted to have to give to the other side. So maybe a document with the reasons why you think that you should be allowed to use it, why it should be a fair use, would be a helpful thing, but maybe not necessarily one where all the reasons against would be. And here you see why I am thinking out loud about this question. I am actually I don't recall I'm trying to recall if this has come out. I know it has come out in some fair use cases where like there are strings of like emails between, say, like executives and product managers about how they know copyright infringement is going on in their platforms. I think this has mostly been for like actually secondary liability rather than fair use. But in some cases of copyright infringement, like documents about like, well, we know this is a little bit dubious, but we're going to do it anyway, has not helped. I think some of those cases have settled, but they may have settled because they knew they were not going to win. This is partially why your lawyer probably always wants to have a phone conversation with you, because you don't want any written records that the other side could have that would weigh against your case. I will say also, I do not work in litigation. I only know from like reading other people's cases, so this isn't something that I have practical experience with coming up. I would hope that it wouldn't come up often. I think it would usually not. I think usually like just like whether it met the fair use factors would matter a lot more than any like justification that you had. Let's see, anyone else? Now I want to go back and see how Meredith answered that, actually.
Well, it's in the recording somewhere. I honestly can't remember, and I won't dare to speak for her. I think
she and
I was gonna say, I think it was also a lot of thinking out loud. So we also, we won't hold either of you to this.
Oh yeah, I want to say that she and I usually agree on like how you would handle things like that, but yeah, I would definitely want to go back and see.
That is one of the other things I like about running both of these sessions, is if you haven't gone back and watched the first recording and you have time, it's often interesting just to get different takes. It's one of the reasons I like Slack too, is that often different people will approach some of these questions from different angles, and it can be really interesting to see like, oh, when I'm thinking about this situation, the primary thing that I'm concerned with is X, but another person thinking about this situation is really focused on Y and the impact that that might have. So it can kind of help to get different perspectives.
Yeah. This is actually one of the things that I enjoy about working with our general counsel, Sarah, is that Sarah has much more of a background in like litigation and corporate law than I do. So sometimes I will run things by her, and it's like, how would you have done this? Like, and I will get good insight because I've usually been on like the transactional side and you know, kind of more of a research. And our newest counsel, Deanna, has just come to us from doing policy in the Canadian government, and she'll probably appear on one of these in the future also, but it'll be good to be working with her too.
One more call for questions. We got about 7 minutes before time to close the session. So,
I thought of something else. Sorry, I thought of one more things I've learned recently that lead me to think this might happen. So what about so I teach history and an emerging, thankfully, an emergingly viewed valid source for study are oral traditions, right? Because there are lots of folks around the world who don't have a long written tradition like some cultures do. And I know that in America, right, copyright is assigned as soon as it's in a fixed format. So if I tell a story out loud, that's not copyrightable. But if I record it, it is. But the story itself could be really old. And I'm thinking of a situation where a story gets recorded, like a scholar says, I'm interviewing these people, I'm recording their stories. Boom, I've got something copyrightable. And I'm going to use that copyright. And let's say I don't know about CC, you know, the Creative Commons licensing, whatever. And I submit my paper to a journal. And of course, the journal has got their traditional copyright understanding. Have I, as a scholar, and maybe that journal, stolen the copyrightability of that particular story? And I'm going to guess that maybe the answer is no, because the only thing that's copyrighted is that recording. But the person who told the story could, of course, they could make a recording themselves and then they can separately copyright it. Do I have that correct?
Yeah, I think that is generally right. Like this is a situation that is like you know, has many layers of things. Like there's a copyrightability. Like first of all, the story itself, like the kind of like, you know, story that like the person is telling, the specific way the person tells it, which may even be like a little bit removed from like the oldest version of that, like. The particular like recording of that person telling it, and then like the scholars like writing about the recording of that person telling it, like all of these might have like different layers to it. Yeah, like so this is a complicated question. I think any particular original like yeah, I think you have not stolen the copyright of that story. Like if the story was in the public domain, it remains in the public domain. Like your particular expression of it, or like one person's particular version of it may still be copyrightable, may be eligible for a separate copyright. For example, that person's retelling may not be like the canonical version, and that person may have a copyright. You have not gotten the copyright to that by setting it down, that because that would be a work that was like created along with the original, like the teller, like they would still be able to publish that story. Hopefully you are never in a situation where you have to sort out those rights. If you're in that situation, you probably want to have some sort of like understanding with your sources about like how a work will be used and what you're going to do with it, so that it doesn't come to a fight.
Thank you. And I'll share a little bit about, so nothing specific yet, but there's a YouTube series called Crash Course. It's a channel and they do all kinds of educational things. I use them in my teaching, and they're in the midst right now of making Crash Course Native American History, right? So it's a series. And just a couple of weeks ago, they published a video. They shared this on some of their socials where they said, we were going to make a video about origin stories, because a lot of Native Americans, right, and First Nations groups have, of course, origin stories. And they said, we decided not to because many of the tribes and the First Nations that we've been working with, and they're doing lots of consulting on this series, they have said that these stories are ours and our stories to
Mhm.
tell. And we don't want, anyone else to tell these stories, because some of these stories can only be told in a certain location by certain people, right? In a certain ceremony, those kinds of things. And so they ran into enough of those barriers that they decided not to make an episode about origin stories at all.
Mm.
And again, they shared with their patrons, and they shared in their socials why they didn't do that. And I thought it was really an interesting question, because as a scholar, I'm interested in learning everything about anyone everywhere. But I also, as a person who tries to practice inclusivity and equity in my teaching, of course, want to respect the values, right, of the people who originally hold those stories. And it was an interesting, because of this, your expertise and where we are today. I was thinking, is there a copyright connection to this? Which is why I asked. I started with that other question.
Yeah, so a lot of what we found in like working with a lot of the like indigenous communities and like people with like long traditions that don't like interface well with the copyright, like their stories are old, but they still have particular like, rules and traditions around the use. They don't interface well with copyright. Like copyright doesn't handle that well, particularly when there's not like a rights holder, but it belongs to a community or a tribe or something like that. A lot of those works, there are some projects that are trying to make the marking of those works easier, and the one that CC has worked with a bunch is called Local Contexts, which is, and they have a bunch of markings about, how for sharing those works that are not copyright licenses, but are guides to like educators and like institutions and knowledge stewards who like about how those works can be used. But yeah, copyright just doesn't interface well with that, like that way of that way of knowledge management, like and the way those communities manage their knowledge. There are a few jurisdictions in the world that do have like copyright like rights around uh, say stories and artwork and such that belong to indigenous tribes. I know like New Zealand is one of them. I forget which others, but there are some that have some rights in the law. The United States doesn't really. But in general, a lot of it is just kind of governed by people attempting to respect those rights and not through copyright infringement.
Yeah, right. Thank you.
Well, we are at right at 3 o'clock. So I want to thank everyone for coming to our webinar today. Kat, thank you so much for sharing all the information, and you guys for the great questions that you asked. This will be recorded. Well, it is recorded. I gotta actually stop the recording here in just a second, but it will be posted on our YouTube channel, and you can go back and refer to that. So I hope everyone has a great day, and we'll see y'all soon.